everybody. Welcome to Off the Cuff, all things healthcare. My name is John Kublank, and I am so excited to be here today because not only do I have one of the most amazing people in the entire world, the extraordinary Arlene Maxim, but we also have a really awesome special guest today. Arlene, how are you? Welcome to Off the Cuff.
I'm good, and Bob is also extraordinary, so I got to just throw that in there. I'm sorry, I don't know what's going on here with my phone. But yeah, today I'm really excited to have Bob here because there have been a lot of questions about the new law that this administration has imposed that will begin on March 15th regarding independent contractors. And independent contractors have been a question for a long, long time with surveyors and with others. And so Bob's going to shed some light on this new ruling. And there are, I believe, 6 items that we have to be concerned about in defining whether or not we are using an independent contractor. The independent contractor is working as an independent contractor and not an employee. So this should be a very interesting topic for everybody in the home care and hospice industry for sure. I mean, other industries are going to be impacted as well. It's not just home care and hospice, but we use so many contract employees that are staff members that I think it's a really good time to talk about this and make sure that we have our policies and procedures aligned so that when that March 15th date hits, we're going to be ready.
Welcome, Bob. Thanks for joining us.
You. Always happy to.
How have you been?
Busy.
That's good. That's good. Yeah. So let's
days.
jump into it. Arlene really did a good job of kind of talking about where we're at, but what is your just overview? We got the final rule of this independent contractor. What, from your standpoint as a lawyer, what did you see?
Well, I mean, it was what I think we expected. We had the notice of proposed rulemaking. We had the proposed rule. We've seen what this DOL has done since the Biden administration took over. We saw how they reacted to the DOL, the rule that the DOL put out under the Trump administration. So when it came out, now I will personally say part of my reaction to all of it is there's a whole lot of angst and whatnot you're seeing. You see a lot of people like the world is ending, but I don't think it's, in some respects, at least for our industry, I don't think it's as bad as you think. Now there are clearly some industries on the edges that are away from us that will be impacted by this rule. And there's, I think, a clear goal to reach certain groups. Like Uber and Lyft get mentioned in the DOL comments. And I think that's intentional. I think if you go back, the Obama administration was very concerned. California's been very concerned about the gig economy and are they employees. For us in home care, we're not necessarily on those edges. And I've said for years, look, most of your workers in home care are in fact employees. They're not independent contractors. That's something the DOL has been going after us for as long as I've been doing this misclassification. And so for us, I think the bigger takeaway is it's a clear signal. If you think you have independent contractors, the DOL is extremely skeptical that any worker is an independent contractor. They think everyone's an employee. And so for you as a home care employer, you should start with that presumption. If you think of independent contractors, you have to understand you'll have to demonstrate that to the DOL auditor, to a plaintiff's attorney, et cetera. And they're starting essentially from a presumption that they're employees. Mm-hmm. And that's very clearly communicated in the comments as to what the lens they're looking at. And that, I think, more than anything, is of importance to us because it tells us what we're dealing with when they come to talk to us about these kinds of things.
Yeah, and I mean, and like Arlene said, this is not a new issue, and like you said, but I do believe this is a good direction for us. And as an administrator, I think my peers in the industry have too much leniency on ways to abuse employees. And even though we have a shortage, I still believe, at least in my area in San Antonio, I'm not having that much trouble finding staff to where it's like I'm down to my last person I could ever find. But it's interesting because I don't think that many people actually look at all the different standards that are supposed to be kept, even in consideration of what is an independent contractor. does that make sense? Like, when I read the rule, I was like, oh yeah, these all make sense. But most of the time it's like, they're just like, oh, we just don't want to pay employee taxes. Like, that's probably not the way.
No, I think you're right. I think there's a lot of, I think there's a couple of things, right? There's some folks who are really kind of gaming the system. They don't want to pay the employment taxes. They don't want to pay overtime. It's like, well, if I call an independent contractor, I can work as much as I want. They'll deal with the taxes. Although in my experience, the independent contractor doesn't actually deal with taxes. They're just like, it's extra money for them. Because as my daughter's finance, she just finished nursing school. She's in her first nursing job. She just got her first W-2. And she's like, man, that's a lot in taxes. I'm like, welcome to being an adult.
Yeah.
It's only going to get worse. As you make more money, you pay more taxes. So I think there's some of that. But I also think, because I've been doing a presentation around the country for years, the top home care employment mistakes. And the one that just keeps coming up year after year after year is misclassification. And I think part is just there's we'll call it an urban legend in home care about who your independent contractors are. And that if I just give you a contract and say you're a contractor, that ends the discussion. But in fact, as you know from the regulation, and this has been the case, and the DOL mentions this in the comments, this goes back to the early 40s and several Supreme Court cases. There are fact-specific issues that investigators look at, that plaintiffs' attorneys look at when assessing if somebody is an employer or an independent contractor. So just calling them an independent contractor doesn't make it so. You've got to look at these 6 factors and look at what they've called for years the economic realities test, the economic reality of the situation to assess it. And so I tell folks all the time, like, well, we have our workers sign contracts. I said, well, that's nice. It will not be dispositive for the DOL. The DOL is not going to say, oh, well, they've got a contract. That's the end of it. And in many cases, in a lot of jurisdictions where it's employment at will, by having the employee sign a contract, you may have given up employment at will now as well. So now you've actually got to have cause to fire them. Otherwise, you're in breach of contract. So I think for a lot of folks, it's that misunderstanding, because people think, and this came up with the DOL in the comments to the DOL, a lot of folks talking about employees and employers should be free to figure out their own relationships and how they want to do things, how they want to get paid, how they want to pay them. And the DOL's position is no, the Fair Labor Standards Act does not allow that. You have to do it certain ways. And because a lot of employers, especially, you get a lot of entrepreneurial folks in home care, they want to try new things to be efficient, to deal with constantly changing payment models and payment structures, value-based, all these things we come up with. They come up with innovative ways to pay their staff, but the DOL says, no, that's not how it works. This is what you have to do. You've got to follow Fair Labor Standards, and we'll look at the economic realities. And so because of that, this urban legend of independent contractors continues, and that's, I think, part of why we keep stepping our toes on it.
I thought one of the interesting parts too was the part where it was talking about, does the employee have the ability to profit? And I think where that comes in, or where a lot of people on the, that are against this would say, well, that's what per visit is, right? They maximize their time. We're giving them a flat rate. They do a little bit faster. They do a little bit slower. That's where their profit and loss is. But is the rule trying to actually talk more about, beyond that sort of scope of making a profit or a loss?
Yeah, and this is something that's come up for years, and this is part of why I'm not sure this rule changes much for us. When it comes to opportunity for profit or loss, the illustration I always give, because whenever I talk about wage and hour issues, we always go through the economic realities test, because despite this regulation, that's been the test for 70 years. So when I've got an employee who can work per visit, right, and the more visits they do, the more efficient they are, the more money they make. The DOL looks at that and says, but they really don't, it doesn't change their profit or loss. It's just more hours worked. It's like, I also say, if I've got 2 jobs, right, I may work at McDonald's and at Burger King. That doesn't make me a fast food service independent contractor. It makes me a guy with 2 jobs. What the illustration I like to use, and I will start by saying this dates me somewhat, and so I've got to find a better one, a more recent one. But for the average for profit or loss, I go back to the IT contractor in Jurassic Park. Like, there's the whole part in the beginning, he's complaining how he's losing money, how hard it is to do a million lines of code. Well, what happened? He was an independent contractor hired by, I forget the guy's name, to do the computers and networking for Jurassic Park. Mm-hmm. And it becomes clear in the plot that he underbid the project. And so, or he managed it poorly. But either way, he bid it. There was a set amount he's going to get paid. And if he is efficient in how he does things, who he hires, what he gets done, he makes more of a profit because he's controlling his costs, etc. And if he's inefficient, he makes less of a profit. And so for the DOL, the way I've seen them look at it, the way I've seen the courts look at it, it's more of that model. If I'm an independent contractor, then I'm controlling my expenses because I buy the equipment, I buy the supplies, I determine hours, I bring in the subcontractors to do the work. You see that with housing construction, anything like that. Whereas if I'm talking to an employee who's just able to pick up hours, their profit or loss, their gross income changes, right? They make more and more, but they don't really have expenses. They get to work, they do the work, they go home from work. They're not buying equipment, they're not buying supplies, they're not subcontracting stuff. And so that's when I've always said per visit pay doesn't change, or hourly pay, or having the schedule open so they can pick and choose what they want. And you see that discussed in the comments, right? There's a lot of discussion from truck driving groups about the difference between extra hours worked versus, for an independent truck driver, deciding whether or not to pick a particular load, because some loads may be more profitable than others. Because that truck driver has to think about distance, gas expense, those types of factors, because he owns the truck, he's driving the truck. Whereas your nurse is just like, well, I've got some free time this Saturday, I pick up a shift, which is, in the DOL's perspective, is not the same calculus.
Arlene? I don't know if you had anything you were off for a minute.
No, but one of the things too, I guess the investments by the worker and the company. So that has to do with, so John talked about the first rule. The second is the investments. So that would have to do with, so independent contractors would not take part in 401ks with a company and that type of thing. Is that correct?
Yeah, usually your independent contractors don't. They're again,
right.
They're,
is that what we're saying here?
That might be a factor, because the rule says they can look at other factors, right? They can look at, there's these six elements plus the kind of bucket of anything else that's relevant. And then within those 6 buckets, they define certain facts that they think would be important. So you could point to the fact that, well, they provide their own benefits. They provide their own 401k. Now, again, in home care, what do we often see? Our nurses, our caregiving staff, we provide the laptop or tablet or point of care device. We provide the software. We provide, back in the day, we provided all the paper documents. We provide the supplies they need to see the clients. We have all that investment. The employee might invest in scrubs, but the rest of it generally comes from the agency. We provide all of it to use because it's our EMR, it's our system, there are systems. And so you see the investments more from the agency side than the caregiver side.
Yeah, and that makes me think about in the situation where I have used independent contractors, especially in the home health side with like physical therapists. They would send us notes that they did out of their own EMR that we would have to upload into our EMR because we didn't provide them with, right. EMR access. We didn't provide them with stuff. They did their job and they sent us their note and then we uploaded it. So I can definitely see how that could work. We did get a question from Shannon Bailey. So I'm gonna throw it up here so everybody can see it. For care at home and the contract nurse, the clinician provides her own equipment, BB cup, blah, 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 supplies, such as car stock, gloves, alcohol wipes, blah, 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 blah. In the case of the organization does not provide, and something I have done often is running to get supplies as needed. Yeah, well, and I do believe, maybe what she's saying, clinicians who contract also bring their own device. Right. I think maybe there's a better argument for PTs and nurses. My big concern, or what I always go to, are the aides. I've seen it more in aides and LVNs where this is becoming an issue, where you have a per visit LVN that does 50 visits at $35 a visit. So they don't get any overtime. They don't get any benefits. You know what I mean? Maybe they get mileage, maybe they do not. So I think there is a point for these nurses that they maybe have the ability to have their own equipment, but it's not even realistic for CNAs. You know what I mean?
No, I agree. And I would say even with the nurses and the PTs, the equipment and investment equipment, that's one of 6 factors. So you've got to keep in mind that there's 6 factors. And I would say I have not seen a lot of clients use contracted nursing. I see a lot with PTs,
sure,
and that's usually through a third party. We'll have a staffing company which changes the discussion, because usually then contractually, because that creates a joint employment relationship generally. But contractually, the staffing company is going to take on all the obligations of the employer, including overtime, to eliminate that for our consideration. And so, yes, if we're talking about RNs, they may have their own equipment, but you still have to evaluate the 5 other factors, and then the catch-all. And then also remember, now more than ever, the DOL is going to start from the assumption that you are, in fact, an employee, not an independent contractor. And so that's always, you've got to work through all of the factors as you think about this.
Do you think that because they came out with this and like you said, it's not necessarily a lot's going to change for us, but do you think that this is going to be the big focus though for this year, and we're going to see a lot of people kind of get mixed up because we're not doing it right?
I think it will continue. I think it's been the focus. I think if you look at the DOL announcements over the last 2 years, there have been a lot of misclassification announcements. Employers, especially in home care, getting dinged for misclassification. I think that there's a website, a portion of the DOL's website dedicated to misclassification as an issue. So this is clearly something. I was actually talking to a DOL auditor this morning, or investigator, about a matter that classification is the entire issue in that case. And we were discussing this rule. I said, well, it looks like this is going to continue. You're going to keep coming to our home care for classification. And while she didn't say they were going to stop focusing on classification, she did say they're more worried about child labor right now than home care. But she also said she's got 3 other pending home care matters in addition to mine just in Indiana. So this is going to be an area of focus. They're going to scrutinize it. And what I tell clients all the time is when the DOL shows up, they're going to assume your staff are employees, and the burden will be on you to prove otherwise. And it's difficult to convince them that someone is an independent contractor. They have, when you have a hammer, everything looks like a nail, and that's kind of the boat that they're in.
Yeah. So I guess the suggestion then, or the solution would be part-time employees, right? Maybe they have the levels where your full-time get benefits, your part-time don't. You have to work under 32 hours or something like that. There's a threshold, right? There just needs to be a set process or policy to get these individuals over on W-2. And again, payroll taxes, I would suppose you have to do that too.
Yeah. And keep in mind too, that the IRS classification, the IRS and the DOL don't always classify people the same way. I mean, they tend to take a broader view as well. But actually, in this case, the DOL concluded that these workers were employees, not independent contractors, but the IRS concluded they were independent contractors. Mm-hmm. In fact, that's how the client has gotten into trouble. So they set up their payroll based upon their CPA's conversations with the IRS that, no, these are independent contractors, and that's fine. And then the DOL shows up and goes, no, they're not. They're employees. And in fact, when I'm doing wage and hour presentations, I like to list the different federal laws and state laws and note they all have their own test for employee versus independent contractor. And you see that also discussed in the comments. One of the suggestions to the DOL is, why don't you just adopt the common law test? Because there's a common law test for employment for basically, so for example, if your employee is in a car accident, are you responsible as the employer? Well, you'd look, there's a common law test to determine whether or not in that moment they're an employer, an agent of the agency for whom you'd be responsible. And that's a different test than the Economic Realities Test for the Fair Labor Standards Act. And the other thing too in all of this, when we're talking about contracted staff, this is only an issue for the DOL if the employee goes over 40 hours. If I've got folks who I've misclassified as independent contractors, they never work more than 20 hours a week. And of course we're paying minimum wage because you're not going to hire someone in home care for minimum wage, right? Everyone's getting 12, 13, 14 or more dollars an hour, especially when you get to nurses and PTs. So when the DOL shows up, okay, we misclassified them, but what are the damages? Now the DOL might try to ding you with a fine or something because you misclassified them, but the employees won't be owed back wages if they weren't owed overtime because they didn't go over 40 hours. So that can sometimes be helpful in an audit. I may have gotten it wrong, but I didn't mispay my employees because they didn't work overtime. And the other thing I point out too, when we're talking about RNs and PTs and OTs, not LPNs, not OTAs, not PTs, but the RNs, PTs, and OTs. You can, if you're concerned with how they're classified is overtime, well, there's this, treat them as exempt professionals, pay them a salary. The RNs, the PTs, they're going to clearly qualify as learner professionals. So if I probably pay them a salary, then the overtime considerations go away. Now there are other considerations. Like, for example, I had a client that did that as a way to deal with overtime. and productivity dropped. Their nurses are like, I'm getting paid whether I do 12 visits or no visits. And so there are ways to deal with that as well. But that's another way to handle it where you properly classify them. And then through use of the exemptions, you can avoid overtime.
Yeah, I think that's where it was. I was part of an agency. I was just a little groundling at the time, but DOL came in, and it was surrounding the per visit, and I want to go back to that because I think it's interesting that there's misclassification. IRS and DOL is not on the same page, but I think even if you're paying a W-2 or an independent contractor, right, which they're not saying there is an independent contractor, they're all employees, over 40 hours, the per visit rate has to change, right? So if you're doing $30 an hour, if you're working over 40 hours, shouldn't that per visit rate go to $45 to make up for the time and a half overtime?
So per visit's an interesting place to be. Now, again, it depends on what we're talking about. If I'm paying an RN or a PT or an OT per visit, I generally caution about using per visit pay because the DOL is very skeptical. But if you look at the Fair Labor Standards Act and the rules, so an element of the white collar exemptions is the salary basis of payment. And there is an alternative salary basis of payment known as a piece rate. And now the illustration they use in the regulations is you commission someone to build, to sculpt a statue for the entrance to your office building. And you pay them a flat one-time fee because it's a unique one-off job. Well, back in the 80s in home care, we concluded, wait a second, home care visits are unique. Every patient's unique. So what if we use the piece basis of pay as an alternative salary? Because it would get them to the exemption. And for us at the time, under the payment all the time, it gave financial incentive for the employees to do more visits, and we got paid more if we did more visits. Everybody wins. Well, until CMS got mad and changed the payment system. The DOL doesn't like it. The DOL says, well, no, home care visits aren't unique like we mean unique. And so they've always been skeptical of it. The federal courts have been a bit more open to the idea. And there are two federal court cases. And what's fun is these two federal court cases are the same federal court of appeals. One found a nurse who's getting paid per visit to be an exempt professional who received a salary basis of payment through a fee basis alternative in the per visit pay. The same court of appeals in another case a couple years later said, no, this nurse was not paid per visit. She's not exempt. She's owed overtime. So you have the same court, arguably the same fact, come to different conclusions. The key distinction seems to be that in the second case, the nurse got paid for the visits, but then got other incremental amounts for other tasks, such as coming to in-services, et cetera. And because there was more than just the per visit pay, the court said, this looks more like you're paying her for her time. This is an hourly arrangement, therefore it's not a salary basis, and so she was not exempt, and it was entitled to overtime. So I'm paying properly per visit. I don't have to adjust the per visit pay because you don't get overtime because you're a salary professional. If I'm paying folks who can't be exempt, so there's not really an exemption that LPNs fit into, PTAs, OTAs, or home health aides. That's where, you need to have some mechanism to track their hours. We should always be tracking hours, but especially the non-exempt folks. I need to know when they go over 40, because at that point they're entitled to time and a half of their regular rate.
And I could be wrong, but doesn't the DOL look at like any sort of productivity points or something, like say like 32 visits or something is actually full time as far as 40 hours if you're doing so many visits? Because again, you have to imagine that there's documentation, drive time, blah, 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 blah. So you can't do 40 visits in 40 hours. Right. So do they look at anything like that, or is it just
no? You've got to keep track. You have to keep track of time. Because I've had clients that do visit, like, well, we give them 1 hour of credit for each visit. I'm like, how much time does it actually take? You got to include the drive time, et cetera. Like, well, it's probably more like 2.5. But that's what the DOL is looking for. And so especially for your non-exempt staff, you have an obligation under the Fair Labor Standards Act to keep track of employee time. But especially for your non-exempt staff, you need to know the hours to calculate overtime. So I've said, again, I don't know that paying per visit to your non-exempt staff makes sense, because what happens is I don't really think to keep track of time. My payment mechanism is visits, so I keep track of visits. And so I can forget to keep track of time, and then I end up with an overtime problem because I didn't realize. So for example, the employee does a bunch of visits, and when I don't capture the travel time, unbeknownst to me, when you can take the travel time and the time in the home for the visit together, they've gone over 40. Oops, I have a violation. So you have to have that mechanism to capture the travel time and then the time in the home. And then that's what the DL is going to look at for purposes of calculating. And the other thing I like to point out with per visit pay, and I've said this for a couple of years now, with PDGM, I don't know that per visit pay makes a lot of sense. Per visit pay arose in an era we got paid more to do more visits. PDGM doesn't want us to do more visits, and I've seen compliance issues arise when I incentivize my staff to do visits. They'll do the visit. You know the old adage, you get what you pay for. And I had a False Claims Act matter several years back where the problem was you had a PT who was writing the care plans, who was also paid per visit and got bonuses for productivity for getting lots of visits in. And this PT was always at the top of productivity, always had the most visits. And then there was a whistleblower. We started doing some investigating. And we brought in an outside PT consultant to look at the visits, look at the notes. And they said, this PT is improperly bifurcating the care. This stuff should all be done together. And she's breaking it apart to essentially double the visits. And so they're doing all these medically unnecessary visits, but the PT was getting all of her visits and maximizing her pay.
Absolutely.
And so there's risks to per visit pay. You've got to think about if you're going to do it, understand the DOL skepticism, understand it's got to just be the visit. You can't pay them the visit plus other things. Otherwise, you're in that second federal case and you're in trouble. And then consider the compliance issues and what you might create because you now you create a financial incentive to do visits, and you're going to get visits. And you may not get the kind of visits you want. And then finally, does giving our employee a financial incentive to do visits align with how we're paid by Medicare? And what happens when I create a financial incentive for my staff that diverges from my financial incentive as the operator? Mm-hmm. And it's just, but we instinctively go to per visit pay because, well, it's what we've always done.
And almost every agency, I'm sorry, John, almost every agency has some type of incentive built in for productivity.
Or they try to push it.
Well, and that's, I always say that's where it's salary with a productivity bonus works. There's clear guidance in the DOL. If I pay you a fixed guaranteed salary, it's at least the minimum, I can give you bonuses as long as the combination of your guaranteed salary and the bonuses does not exceed 1.5 times the guaranteed salary. So if you want a productivity bonus, you pay the salary and then you can set a bonus and get it there. With the visits, again, if all they get is a visit pay and then at a certain point they get a bonus, there may be an argument that that's not hourly basis pay. That's a bonus like you'd give to a salary professional. But you need to be very careful because I've seen some models where here's the base visit pay. And then there's points involved. If you do this thing, you get this additional pay or this thing. Now you're getting paid for everything. And I think that's squarely within the second federal case that says that's an hourly basis pay. So you got to very carefully think about per visit pay because the DOL skeptical, they're clearly focused on home care right now. And they've been very clear they don't like per visit pay.
How do we solve the problem with these clinicians who want to be paid for documentation time? I mean, I am a huge proponent of doing the documentation in the home at the point of care. I just think you get much more accurate information and you're not losing with your memory. After you see 5 or 6 patients during the day, they kind of all run together. And so the accuracy of your information doing documentation at night, because I could see the DOL coming in and saying, well, this person spent X amount of hours, but they weren't complying with what the agency required, which is point of care documentation. So now they're taking it home and adding on more hours.
And that's a problem because if they are going home and they are working, then argue that's compensable working time. But the flip side is they're not supposed to be. And the concern I have when the employees start taking the documentation home, obviously, one, to your point, how do you know what you're documenting? And that's when you get all kinds of interesting wrinkles in your documentation, such as I've seen where every single vital sign is the same, like over a week or two of visits, their blood pressure, I'm like, come on. Like,
by the third glass of wine, pressing that copy and paste button is a lot easier at home.
Right. And I had one we did the investigation. It was the EMRs. It was earlier in the early days of the EMRs, but it was all still time stamped. And the employee was signing her notes at like 1 or 2 o'clock in the morning on a Saturday morning. And so was the patient, because they required the patient's signature to verify the visits. I'm like, I don't think the patient really signed this note at 2 a.m. So, but then the other question I always ask folks is, okay, if your staff is doing documentation outside of the patient's home, what happened to the notebook that nurse had? Because I promise you that staff member is writing things down in a notebook and taking it home. And that notebook is chock full of PHI. Did they shred it when they were done? I bet they didn't. And it probably just got tossed in a trash can or sit on a shelf. There's a HIPAA component to this where you've got HIPAA compliance issues, you're not following HIPAA policies. Where are they documenting it at when they're not in the patient's home? Are they documenting at Starbucks? Are they at their kitchen table? Who else can see? Like, we have all these other HIPAA considerations. And then the nurses and staff who do this, they're thinking out, well, I've got to get to the visit, I got to get the stuff done, I got to get home. And it's convenient for them, but they're not thinking about the compliance issues, and they could get in trouble just as much as we could if that comes back to haunt us later. If, heaven forbid, someone find one of those notebooks somewhere and it's just got all this patient information in it, now we've got to breach. The nurse, it won't be hard to figure out whose notebook that is. The nurse is going to potentially have professional ramifications. So my first thought is to educate the staff on why we do not document anywhere but the client's home. And then two, when they do, if they come to you and say, hey, I worked an hour at home last night documenting, whenever I get a call from a client about an employee wage dispute like that, well, they didn't turn their documentation, so I want to hold their pay, or they say they worked 2 extra hours. My first question is, how much is the check you're going to have to write if you pay them the 2 extra hours? And they'll tell me, I go, okay, well, you've already spent more than that talking to me. Just add it to their paycheck, discipline them upon following policies, and move on. You're not going to fight with them over a $30 discrepancy. It's just not worth the effort. And also, if you do fight with them, the rules are such that if you lose, you pay the back wages, you pay liquidated damages, and you pay their attorney's fees. So I've had clients, I had one, it was a $250 wage and hour dispute. And I told the client, I said, look, I get it. You think she's lying, you don't believe her, but it's cheaper to pay her to go away. Just give her the money. And he was insisting.
Don't use her again, right? I mean, don't put
Right.
yourself in the same situation.
Discipline her. Pay him, discipline him, and move on. He fought it. And at the end of the day, paid her the back wages, paid her liquidated damages, paid my fees, and paid her attorney's fees. That $200, $300 dispute turned into $15,000 total.
Yeah. Yeah.
And he was, and after I told him, I said, this is why I told you to pay her. You would be less mad if you'd given her the little amount than giving her the big amount. So when you've got a wage dispute like that, just pay them. Never use their pay as a form of discipline. Then move them through the discipline process. And I had this conversation just last week at a conference. I said, eventually you're going to terminate them. If they're not following documentation standards, you're going to terminate them. And a couple of people are like, but we can't terminate them because we can't find anybody else. Like, they know we can't terminate them because there's no other staff coming. I get that, but at the same time, you can't have people who keep breaking the rules, especially with documentation.
They're using that to their advantage right now. Let's go back to the point of care documentation, because like I said, I've just been preaching that for years. Well, you know, Bob, years and years. And I did not know until about maybe it's been longer than 5 years, until you said that notebook is not HIPAA compliant. And so I talk about that every time I do documentation training. But I do think organization, and I know this is a competitive market, but I do think organizations need to be very careful when they're choosing an EMR, because some of these EMRs are so complex that it literally takes hours to do the documentation, and having to sit in a home and do that is a concern. But patients don't want you to sit there for 3 hours and do your start of care documentation. But my point is, I think that's a valid issue when organizations are choosing a software to use. They need to think about that. How easy is it going to be for that clinician to do the documentation at the point of care, or are they going to run out of time and have to leave and do it later? And like I said, then all of this that just all jumbles together, and every patient looks the same, and vital signs are the same, and findings are the same. Everybody has within normal limits on everything. I do think that have you ever thought about that should be a concern when choosing software, that they need to consider that?
Well, yeah, and you and I've discussed this in other contexts, that there's so many EMRs out there right now, and you do have to,
Very competitive. Mm-hmm.
you do, and so you have the opportunity to look at different ones, and there's a certain level of preference, right? Some people like Apple, some people like Windows. I spent years as an Apple fanatic, and now after 20 years as a lawyer, not a lot of lawyers use Apple. I've gotten comfortable with Windows to the point where I find myself looking at Apple as somewhat unfamiliar territory.
Mm-hmm.
And so there's some of it's just more of a subjective preference, but there are things about each software that makes more or less sense in a particular context, particular workflow. And I think the issue is just as much the software and its interface as it is the failure of providers to think through implementation.
Mm-hmm.
A lot of times what I see is we bought the software, installed the software, and away we went. And admittedly, if you're a smaller company, you're not going to spend as much time and money on implementation because you don't have those resources. I've seen some large companies implement EMRs where the EMR companies customize the interfaces to look like their documentation. They're doing a ton of work because the client can afford to have that customization kind of work done. But you still have to think through the workflow. You've got to think through, how's my staff going to use it? How's it different from the current workflow? And then you've got to think through training. I think back, before I got into all this, I was in IT, and I remember the first job I had out of college. This goes back to the mid 90s, and we were looking at Y2K was coming. And so all the software where I worked had been written in-house, and we were working to switch over to third-party software that could deal with the 4 digits for the century so we wouldn't collapse on Y2K. And part of that was training. The software company came in and we did a lot of training because we were the support folks who were going to have to write back off, support code, deal with troubleshooting, things like that. There's a lot of training for us to get used to. Okay, this is how it used to work. Here's how I have to do things now. And I think sometimes that gets neglected because we think, oh, it's just software. It's, it's like Microsoft Word. Well, I think I use maybe a tenth of the features of Microsoft Word because I've never actually taken the time to do any training to learn it. It's the same thing. And the improper implementation can lead to all kinds of other issues. My favorite being, like you just mentioned, every visit note looks the same. Every plan of care looks the same because in an effort to we're trying to make the clinician's life easier. So it's a lot of check boxes, a lot of autocompletes. And then when you get audited and you see all the documentation together, you're like, wait a second, this all looks the same. And so we have to think that through because the software is not a silver bullet. It doesn't magically change anything.
That's right.
Mm-hmm.
And organizations can't use their software as a standard of practice. And that's another thing that frustrates me sometimes because I get in the middle of a survey and the administrator says, well, our software, and the surveyor brings up a point and the administrator says, well, our software won't allow us to do that. Well, that's not the surveyor's issue. The surveyor's issue is you've got to comply with the conditions of participation. And it has to do with reimbursement too. The same thing. I hear those excuses all the time. Well, our software doesn't allow this. So I think that, in talking about this and talking about employees and retention of employees and that type of thing, I think that that's something folks need to be really well aware of. The fourth point on these rules has to do with the control of the worker, including whether the employer uses technological means of supervision, reserves the right to supervise a disciplined worker, or places demands on the worker's time that do not allow the worker to work for others or work when they choose. So am I correct in understanding that just means that they can't pin you down to only doing their job and you have the freedom to go other places to do other work in other places? Is that correct?
Well, that's what that last fact they mentioned there does. Yeah, the control looks at a number of other things, but that's one. And you'll see that in, for example, states where non-competes are allowed, you'll see the employers will have the home care employees sign a non-compete that not only says you can't do these things after you leave employment with us, but while you work for us, you won't work elsewhere. Now, some will say you won't work elsewhere unless you get our permission in advance because we don't make sure that if you're working somewhere else, it doesn't conflict with you doing our work. And so the people look at that and go, well, you're telling them where they can and can't work, so that's control. I've put in the past, we have a lot of control. And this is one of the reasons why I think we even under the old test or under the 2021 rule, where control was a primary factor, why we would be employers, because we have a lot of control. We have to, right? You can't tell the surveyor, well, I don't control my staff. They do what they want. Well, that'll get you in jeopardy every day of the week. We have schedules, we have plans of care. We expect the workers to follow the plan of care, to follow the schedule. Most agencies, if you're a no-call, no-show, we're going to terminate you on the spot. I can't have you not show up for work when scheduled, because as the license holder, as the Medicare certified provider, I'm expected to do what's in the plan of care. I'm expected to meet the schedule. And so I have these expectations. So I have to have a significant degree of control. In fact, many years ago, I had a client who got an opinion letter from an attorney. They weren't a Medicare home health. They were a licensed, non-skilled home care. So they had Medicaid waiver, they had a state license, et cetera. And the opinion said that they were not an employer and that they didn't have control. And I said to the client, I said, do you really think you can take that position with the state that issued your license, that you can tell them you don't have control? You're required to have a service plan. You're required to meet with the client every 90 days to discuss the service plan. You're required to make sure that the employees follow the service plan and document it. I said, I don't think you can tell the state, this is in Indiana, the state of Indiana, you don't have control. And once you have control, then this fact in this opinion letter changes, and now you're the employer. Because you have to have control to be that's part of being a licensed provider.
That's part of the conditions. All right.
Right. I think it's hard for a home care provider, home health hospital, or licensed private duty to argue they don't have control. Now, some states still allow registries, and as a registry, you might avoid being the employer. But that's a very fact-specific question. What I said to registries is somebody's the employer, and I've seen the DOL sue families over time. I had one client, experienced home care operator, but independent contractors to take care of an aunt who was dying. And about 2 weeks after the aunt died, the IRS showed up, and they're like, we don't think these are independent contractors. And the only reason the IRS went away was because the employer, in this case, they concluded that the aunt who had died was the employer. And they went away because she was dead. Like, well, we can't get her now. So, but the takeaway was, somebody here in this registry model was the employer for the IRS purposes and the deal. So I would, to the registries, I would just say, you may be under state law, registries may be allowed. Some states have gotten rid of them because of concerns about quality and things like that. But in that context, the DOL is often going to look at somebody and go, well, somebody here has to be the employer. And so I would be concerned that the family becomes the employer in that context.
And with the when you said the monitoring, Arlene, that made me think of electronic visit verification as well. It's like we get our technology is so great, but you kind of pin yourself in. You give them access to your EMR, and they start to document in the home, and boop, now it's tracking where they're at. Wouldn't that also? I mean, it's like these little nuances, but I guess the bigger point that I'm looking at is like it is very difficult to really have an independent contractor. Very difficult.
Bob, let me ask you this. So when the clinicians claim that they're independent contractors, they're not working for a staffing company. They're not working for a larger company, like a lot of therapy companies are out there and they subcontract different therapists. That's a little different. But if you're coming into an organization, you're saying, I'm an independent contracting nurse and I would like to pick up a few visits a week. Should I, or would the agency expect, or should they expect that clinician to have a business, an LLC or something already established, so that they have that documentation that they can use as support? Or is that doesn't?
Well, I mean, I think it's a fact that would help, right? The DOL is very big on, they look at the totality of the circumstances. So if I'm an independent contractor and I have my own business, then one step of being an independent business is you have formed a company. You have an LLC or a corporation. You have, filed for tax. You've elected tax status. You've got W-9s, those kinds of things, so that you can show, look, I am a company, right? Here's the company. Here's what we do. I know a lot of independent consultants that do that. They are, they form their own LLC. They're the only product of the LLC, right? It's just them. But that is a factor. Your point is, well, this is how businesses operate, right? They form corporations, they form businesses, they follow the corporate formalities, they take these steps.
Yeah, I had an interesting situation a couple years back where I came into an organization, and they were a large organization when I joined, but they were sort of a mom and pop mentality, right? Like very good heart. But this one situation is I had one of my employees cleaning my offices. Okay, great. How are we paying her? Oh, we're just paying her a stipend. But she's our employee. Like, you're not paying her overtime, whatever. So like I had to talk to this employee. So I ended up having that employee go out and start a business, right? Like, okay, if you wanna clean the office as a cleaning crew, this is the way that it needs to be done so that we can pay you properly. Because if I'm just paying you as a person to clean, you're working overtime essentially, right? Like that's what I took from it. That's why I went the way that I did. But I think oftentimes we overlook it, and we think we're helping these people out too because they want the extra money or whatever. But it's still not right, I guess, is the point.
Right. And the fact that they form an independent company, that they have an LLC or corporate, has an EI and all those things, that's not dispositive. The DOL could still come in and look at all the other factors and go, well, that's nice, you formed your company and got your EIN, but you are still an employee. You'd have to look at the other factors. So, for example, and I think they talk about this in the comments, that do they have other clients? And they do distinguish between having other clients and working multiple jobs, and it does raise a question: how do you distinguish that, right? If I'm a company providing independent contractor staffing elsewhere, how to distinguish between who's an independent contractor working multiple jobs? And this was a comment raised by some of the, I think it was writers, folks who do technical writing freelance. They're like, well, we view ourselves as independent contractors with multiple customers, but the concern is the way the DOL has written the rule, they'll view them as employees with multiple employers. And so there's some of those where I think there's still a lot of, the DOL likes to say, well, this rule makes it much clearer now. And I don't think it makes it any clearer. I think for some of those folks, there is a question about, well, for years I've thought of an independent contractor, am I now? And so you've got to look at all these facts. And so I think what you're saying is that's a fact that could be helpful to the argument someone's an independent contractor. We just have to look at the other factors to assess whether or not they really were independent contractors.
And we're not saying, I just want to reiterate, summarize what we've been talking about, because I've learned a lot today. It's not that really the big concern is when they hit over 40 hours, right? It's
right.
You're breaking the rule, right? If you're misclassifying, but it's misclassification with the over 40 hours a work week is really the biggest issue that we're going after, because the DOL, and I think ethically, we shouldn't work people, to their bones, without at least compensating them, at least them knowing what they're signing up for. And I think oftentimes I've seen from a cynical standpoint that you have these extremely hardworking individuals that just want to provide for their families, and they'll take all the visits they can. And the company's like, yeah, sure. Why not? Like, go ahead. It's not hurting me any because I don't have to pay you any different. And I feel like it's frustrating because I have these conversations with owners and different people, and they don't get it. But it's like, but we're taking advantage of these people to some degree, right? Like, isn't that the issue? Like, I don't know. It flabbergasts me sometimes.
No, it is. It is. I think the DOL would call it taking advantage of wage theft, whatever you want to say. They're employees and they're working 40 plus hours. They should get overtime. And if we're not paying it now, the DOL may still take issue with you misclassifying folks. The question simply is, what are they going to? There's no overtime to recoup because they haven't worked over 40. But usually you see this come up, it's folks who are working a lot of overtime and have been misclassified as independent contractors. And then there's a sizable bill that comes due because the DOL says, no, these are employees. They should have gotten overtime.
And this typically comes from like one whistleblower, right? I mean, there's a reason these people are coming in. It's like you work someone in the bones, they're picking up the phone.
Yeah, and plaintiffs' attorneys are actively looking for cases now. This is an area where you'll see, you see the mesothelioma ads and the
ambulance chasers.
Yeah. I think down in your neck of the woods, what's their name? It starts with an M, I think. Oh, they're all over the place now. In our neck of the woods, it's Daryl Isaacs, the Hammer, or Ken Nunn. those group looking for car accidents and stuff. But now you have a cottage industry plans attorneys who are looking for employers who have wage and hour violations, because if they win, they don't just get, a percentage of take. They can have the court order you to pay their attorney's fees based on their hourly rates. And so I've seen commercials on TV. Do you feel that you haven't got your entitled overtime and haven't been paid overtime? When you see attorneys doing TV ads for an issue, then they think there's money to be had there.
There's money out there. That's right.
And once they find one employee, here's the other fun fact on the Fair Labor Standards Act: they can bring what's called a collective action. A collective action is a wage and hour class action where they will sue you. An employee sues the employer on behalf of themselves and other similarly situated employees. So now all of your employees. So if it's your home health aides, for example, one home health aide comes forward, soon I have all the home health aides. Now all the overtime for all the home health aides comes into play. And these cases can get very expensive very quickly. In fact, they can be financially ruinous for a company. If you
the organization I was with got hit with a $90,000 fine for LPNs and CNAs.
I've got one right now where the opening offer from the DOL was $700,000.
Yeah, I was going to say that doesn't sound like a lot to me, John.
And I thought 90,000 was all. Now that's just pennies. Good night. We got off.
That's chump change, John. Yeah, that you guys dodged a bullet.
And the thing was, like you said, we could afford it. I mean, I think oftentimes there is no $700,000, especially in home health, to come out. Like you said, it's ruinous.
Yeah.
No, a DOL audit can wipe you out.
Yeah. I want to ask you what your recommendations for home care companies and hospice companies to keep them out of trouble. I have a couple ideas, but before I do that, before we started this broadcast, I asked you about the issue where surveyors were asking about the difference, the contract employees as opposed to employees. And there has to be, the conditions say there has to be at least one discipline that's always a full-time, always an employee, not a contract employee. So I've heard recommendations from surveyors saying that we should always put speech therapists, because we rarely have multiple speech therapists and they don't use a lot, or home health aides, because you always use them as an employee. What is your recommendation on that, Bob?
So what I have said, and when this comes up with my clients, it's usually because we want to use a professional employment organization or something else where we're going to put all of our staff into a single bucket. And usually it's because we have multiple providers, multiple employers. We want to consolidate staffing. And so that PEO will be the employer, right? We're not just treating these folks like independent contractors. We're creating our own staffing company because you get scale for benefits, et cetera. But then the question becomes, so you've got home health, you have the requirement that at least one qualifying service be provided completely by W-2 employees. Right. And that's been my position for 20 years. I might have enough work for a part-time speech pathologist. So we'll hire the speech pathologist, put on a W-2, they get employed part-time. Everyone else goes to PEO because the part-time employee is not getting benefits and that kind of stuff. We don't care. And then the rest go into the PEO, the staffing company, where we're putting them for other purposes. And that complies with the COP. I actually had a conversation with the folks in Baltimore because we were discussing that. And then the context of hospice, we have core services. It's not as easy to do with hospice. But I asked about home health, and I said, well, this is how we do it in home health. And I forget the very helpful lady's name in Baltimore who oversees the home health regs. And there was silence. And she goes, my jaw just hit the floor. And I go, do you disagree that that's the correct way that's how the rule applies? And she goes, no, that's correct. She goes, I just didn't think anyone was doing it. And I'm like, oh, we're all doing it out here. So even CMS in Baltimore agrees that that's acceptable. They just didn't know because and here's another wrinkle in all this employment. CMS's vision of what the home care and hospice industry looks like is still stuck in the 80s. Our more complex employment structures and corporate structures, they don't have a lens for, which has created all kinds of interesting issues in surveys related to administration tags and things like that. But if you've got one part-time speech pathologist, and the only thing a surveyor looks at, so here's another fun one. The DOL, determining employee versus independent contractor, looks at the economic realities tests. The only thing a surveyor looks at is a W-2. Because I have an argument to surveyors, okay, we didn't give them a W-2 necessarily. but there's a joint employment relationship here between us and the staffing company. So they are our employee as well. We have just contractually agreed that the other company is going to issue the W-2. And the response again is, all that matters is who issues the W-2. Okay, well, that's not helpful and not actually what the law says. So you've got to be careful with that. But if you've got that one speech pathologist and they're a W-2 employee, then everyone else can be staffed.
A combination of things and the other.
Right. Again, with the independent contractor, understand from the DOL's perspective, they're probably not contractors. If they might have been before, I don't think they are now, because the DOL is clearly signaling there aren't independent contractors.
Yeah. Okay, so in our last couple minutes we have left, what are your recommendations for home care companies and hospice companies staying out of trouble with this? I'm really concerned about a number of organizations that I've been in and knowing what they actually do and what is perceived as an employee and what's perceived as a contract person.
Specifically in home health, I think home health is much bigger concern, at least from my experience. Hospice, we have a lot of full-time, we try to keep full-time staff, you know what I mean? But
yeah,
home health.
Yeah, a lot of it's sloppy record keeping, I think, on the part of, the personnel department or administrative department. But what would be some of your recommendations for operations like we represent?
Well, I think the first one is recognize, to borrow a phrase my kids like to use, read the room. And the room right now is there are no independent contractors. And for us, they've always treated us that way. I have rarely seen a DOL investigator go, oh, yes, that employee is an independent contractor. And based on that, understand just because you call them independent contractors, you give them sign a contract, otherwise doesn't make it so. The government's going to apply this test. And if you read the comments, they're going to apply that. They dismiss it, but many of the commenters said you're putting your thumb on the scale in favor of employee. They are. They think all of your workers are employees. Mm-hmm. I've been involved in a number of these investigations. I've got a couple going on right now. I've had some very lengthy discussions with DOL about the divergence between Medicare and Medicaid policy and DOL policy, and how what we were doing in home care in 2023 is not what the Fair Labor Standards Act envisioned in 1937. This is not that. This was not anybody's horizons in 1937. So it doesn't make sense to regulate the home care industry the way we regulated farming and industry in the 30s, but they are. And so understand that you really are wise to treat all of your workers as employees, track the hours, pay overtime, properly deal with taxes. If you're using a staffing company, right, that may be an exception because that's a joint employment. Make sure your contract is clear that you're using them, but that the staffing company is taking care of overtime and those types of issues, because in a joint employment relationship, you can both get in trouble if one of you makes a mistake. And if you do those things, if you're classifying everyone correctly, if we're using our exemptions properly, we're tracking our hours and paying overtime, you want to fear. Now, the response is, but it might change your economics. It might change your model because now you got to pay overtime. And I have clients say, well, I can't afford overtime. I don't, if I have to pay overtime, they're going to have to work so much overtime because I've got such staffing problems. Well, I can't help with that. These are the rules. And there's a legitimate disconnect between what the DOL wants and what CMS wants and how much CMS is paying us. Someone else has said to the DOL, we would be happy to pay our employees much more if you could walk down the street and tell CMS to pay us more instead of continuing to take our money away. Like we're caught between a rock and a hard place. But when the investigators show up, they're very much on the employee side. They can be reasonable. I've got plenty of investigators who are very reasonable. They're easy to work with, but they're very insistent that these are employees who should have been paid overtime. So you have to start from that presumption. And then I tell clients, if you think you've got an independent contractor, if you think, oh, we're different in this context, this is an independent contractor, get a written opinion from an attorney. Go to your attorney, get them to put that in writing. It used to be that would at least protect you potentially from liquidated damages because you had a good faith defense. I am not certain with the current DOL that will help you anymore. It's good to have it, better to have it than not have it because it does provide you with some defense. But I have a case right now where They acted on advice of their CPA. The CPA put it in writing. We have shown that to the DOL, and the response is, you're still paying liquidated damages. So it may not help you because, again, the environment right now, the current DOL is very much a pro-employee DOL.
Mm-hmm.
So you have to understand that. Look, I'm just the messenger. I had a heated discussion with
Bob.
I know. I don't like it any more than you do. I have pages of notes where I have made snarky comments about what the DOL says in this rule because I'm like, that's not right, or why are we doing this, or you're missing the point here. But that's the rule. And then the other one little thing I think that's being overlooked in all this is it appears we've reached a new level in the world of administrative agencies. It used to be that when administrations changed, we had new interpretations of the current rules. But what we're now seeing, and it'll be if we get a different party in the next election, so Republicans take back over the White House, eventually it swings the other way. But this administration has gone one step further, and they're actively passing laws or regulations to completely change the written rules from the prior administration. And it's funny as you read through the comments how they're trying to explain how on January 20th, 2021, this rule made perfect sense. And on February 1st, 2021, it doesn't make sense anymore. And the whole thing, like, this is completely illogical. But from whether you like what they did or not, from an employer standpoint, from a healthcare operator standpoint who has to comply with regulations, this raises the specter that every time a new political party takes over the White House, it won't just be interpretations that change, but the actual written rules that change. And I raise that because that will make our compliance burden so much more difficult. Yes. If the targets change that radically every 4 to 8 years. So that's another one. We just see how it plays out. The short-term takeaway in all of this is the DOL is very clearly signaling they have a very expansive view of who is an employee. And given that, we should, I think, generally err on the side of our workers, our employees, and act accordingly.
Awesome. Bob, thank you so much for coming on our show. Arlene, it's always such an honor to get a share screen with you.
Thank you so much, Bob. Thank you very much.
Yeah, I'm always glad to be on. So it's always fun talking to you guys.
Thanks, Bob.
We're going to have you back.
For listening. We will be back next Wednesday. We have a very exciting, or is it Wednesday or Thursday?
It's next Wednesday. Yeah, we have
very exciting.
Rory from NHPCO and Zandra Ellis from Access is going to be visiting us, and we're going to talk about the new guide program that CMS has introduced. In fact, those applications have to be in by next week. So Rory's going to be talking to us about how that can help us perhaps put some of these dementia patients into a palliative care situation, and we actually get paid for it. So that'll be an interesting conversation, and we look forward to that.
Maybe they'll be able to pay overtime then.
I doubt CMS is paying that much.
Yeah, probably not. Yeah.
Awesome. Well, thank you all for watching. We'll be back next week, and we thank you for watching. I guess I said that, but anyway, y'all have a great day. We'll see y'all soon. Bye.
Bye.